Hello, everyone. Dr. Souvik Roy, Professor and Associate Dean at Adamas University School of Law and Justice. This side. And yeah, so we'll take our conversation ahead with respect to hurt and grievous hurt. And in the earlier video, we had looked into the aspect of both hurt as well as grievous hurt. Now, if you really look into it from the standpoint of how essential it is to human entity at large, one thing is clear by now that clause 8ly of grievous hurt under section 320 was something that was very intriguing. And I did mention, I remember in that earlier video, that Abdul Sadiq versus State of Maharashtra, and how edge generis principle was embedded in order to give a correct interpretation to that provision under clause 8ly of section 320 of grievous hurt. And we understood that, the comma had no significance and therefore or is to be taken, and that for 20 days, taking the intent of the legislature with complete objectivity in mind, we went ahead to know and to understand the whole idea of grievous hurt. Now, hurt and grievous hurt doesn't end there, because if you look into it further, when you look into section 321 and 322, it talks about voluntarily causing hurt. Also, it talks about voluntarily causing grievous hurt. Now, voluntarily, the word itself is defined under section 26 of the Indian Penal Code. Voluntarily means out of your own volition, own will. There is no coercion. So basically, you are doing it upon your own will. Now, in this context, something very interesting that, one of the defenses when a criminal or an alleged criminal or an alleged perpetrator or an alleged offender does something or commits an act with mens rea. Remember, I had mentioned mens rea as a guilty mind in my earlier video. Clearly, I mean, it is understandable that for obvious reasons, mm, there is this defense called actus me invito factus non est mens actus. Act done by me against my own will is not my act. So basically, today somebody puts me at gunpoint and says, do this, and I do it. Yes, I do give consent, but it's not an active consent. It is a vitiated, polluted, or a polluted consent under coercion, under threat, under undue influence that I've been put on gunpoint. So to save my skin, I'm doing an act because I've been compelled to do so. So given the choice, given the option, given my own will, given my own volition, I wouldn't have done that. And why I'm saying this is in order to help bring more clarity into this entire aspect of voluntarily, which is separately defined under Section 26 of IPC. So here, the person who is causing it, the hurt or the grievous hurt, and like we have mentioned, the concept of hurt is pain, disease, or infirmity. Very interesting. Now, taking that discussion ahead, uh, it says that whoever does any act with the intention, that is the evil intention or the guilty mind that I was referring to as per Indian Penal Code, and that means mens rea, or with the knowledge. So, knowledge means the awareness of consequence. So, one is you have intention, you intend to do something. The other one is knowledge. You are aware that doing this would lead to this. X will lead to Y, and therefore I do this knowing that X will lead to Y, or act X will lead to a consequence that will be consequence Y. Mm, Now, thereby that person likely to cause hurt. So, of course, there is no inevitable here. Inevitability is here. Now, there is a explanation attached to section 322, which is voluntarily causing grievous hurt, which says a person is not said to voluntarily cause grievous hurt except when he both causes grievous hurt and intends or knows himself to be likely to cause grievous hurt. Now, say for instance, somebody slaps here near the earlobe and there is a tumor inside. The person is not aware, and the tumor bursts out. person did not intend to hit or cause the effect of bursting the um, tumor, if the person does not have a prior knowledge or information that there is a tumor inside, and therefore he does it with the intention to cause hurt, but the result is that of grievous hurt, then it becomes a very dicey situation for lawyers, for judges in the court to give a decision. But the idea is, yeah, somebody do not know that there is something here inside and therefore does it. So therefore, there is lack of intent or lack of knowledge about a particular information. So he cannot be held liable for that. But if I know that this person has something like this here, and therefore deliberately I hit it in that particular area to get that desired consequence, and then act naive and innocent that, oh, I did not know something like this was present, that is definitely not something done, and that's definitely a wrong in the eyes of the law, and therefore the due punishment will be given. And yes, so this is exactly what it's meant here. So this is an illustration, interesting one. A intending or knowing himself to be likely permanent to disfigure Z's face, that about to disfigure, like, pretty much aware that Z's face will be disfigured, gives Z a blow which does not permanently disfigure Z's face, but which causes Z to suffer from severe bodily pain for 20 days. Now, the intention was to cause damage or permanent disfiguration of Z. This is person called Z. I want to disfigure his face. I do that. But in the process, I fail to disfigure the face because of XYZ, whatever reasons. But what I did led to that person being in extreme pain for 20 days or more. So therefore 320 clause 8ly comes into the picture. However, 320 clause 6ly, which I actually intended, does not come into the picture. So despite the fact I won't be held liable under 320 clause 6ly, but I'll still be held liable under 320 clause 8ly, and then still therefore I will be held responsible for grievous hurt. Simple. Now, further, if you look into 323, the punishment for voluntarily causing hurt may extend to 1 year or fine or both 1,000 rupees, etc. And obviously, when it comes to punishment for voluntarily causing grievous hurt under section 325, it may extend to 7 years. Now you see, 1 year on one side and 7 years on the other side. And of course, imprisonment or fine or both, and etc. So, which is to say, therefore, depending on the gravity of the offense, whether it's hurt or grievous hurt, the court will formulate a sentencing, a decision making with regard to the punishment. And that particular punishment will be based on the damage caused due to the intensity of the offense that has been committed. And then, subsequent to that, there is another provision as well, which talks about causing grievous hurt by deadly weapons or dangerous weapons. Like I mentioned in my previous video, somebody coming with a sharp dagger or a stick or something, or a knife for that matter. Again, it bloats up. Further, certain amendments did come into the picture. As I told you, I'll refer to the Bear Act. Voluntarily causing grievous hurt by use of acid. So basically, what you're referring to is acid attack, which is something which has been taken in quite seriousness. And 326B, that's another amendment that come through, that attempting to throw acid, whoever, through explanation one, for the purposes of 326A. And this section, acid includes any substance which is acidic and corrosive character and burning nature. So the concept of acid has also been discussed within the framework of the law. And what is, or what are the component that makes up acid, and what could be termed as acid in the eyes of law when such attacks do take place, has been given by explanation 1 to section 326B, and has acidic or corrosive character or burning nature, capable of causing bodily injury leading to scars or disfigurement or temporary or permanent disability. Look at the words. Scar, if you talk about scar, you talk about scratch and wound in my previous video about pain, disease, infirmity, pain, grievous hurt, or simple hurt, or disfigurement. There's an element permanence attached to it, and the gravity is humongous, whether it's temporary or permanent disability. And further, it has been mentioned in explanation 2 to section 326b that for the purposes of section 326a and this section, permanent or partial damage or deformity, again the word, another strong word used, deformity, shall not be required to be irreversible. It is not important whether the deformity is irreversible. Even if it is reversible, the damage caused is of extreme order. And therefore, acknowledging, knowing, understanding, and giving enough priority to a word like deformity, damaging, and etc., all this put together, it is only but obvious and only but evident that it is irreversible or not is immaterial. The thing is, something corrosive, something with a burning sensation has been attacked with on a person. So, these are in brief, there are multiple other voluntary cases of hurt and grievous hurt, the more important ones. And from there, slowly but steadily, if we go strictly by the provisions of the sections of the law, um, we move in to section 339 and 340 as well. Now, uh, there is something called wrongful restraint and wrongful confinement. Now, this is again something very interesting. Mm, say, for instance, today in this module 4, as we move further, we'll discuss other things as well: insult, intimidation, defamation, force, criminal force, assault, everything. The concept of restraint and confinement is something I feel is extremely interesting. Why? Because most of the crimes under the penal laws has been put forth keeping in view the mother law of the land. And if I ask you which is the mother law, the crux, the basics, the fundamental of all the laws from where it's rooted through, it is the Indian Constitution. And if you look into the Indian Constitution, Article 19, you'll be definitely understanding that fact that, one has a right, a human being has a right to move, to walk, to run, to maneuver, to cut across by way of free movement in any direction, which is a right, which is a fundamental right bestowed upon us, the individuals of the state, the citizens of the country, and the subjects of the state, although subject comes with the connotation of colonialism and slavery. So I'd amend that to a citizen. Now, purely from that point of view or standpoint, let me tell you, is the right to move in any direction a free right, an unfettered right, which cannot have any kind of restriction whatsoever? The answer to that is no, it is not. Free right, and there are restrictions to it because, like any other fundamental rights under the Indian Penal Code or under the Indian Constitution, even the right to move in a particular direction is subject to reasonable restriction. Ponder your thought upon it. Now, when you look into the aspect of a right and how it has been put forth, let me tell you something interestingly enough. Uh, The right to move in a particular direction can be curbed under the ambit of reasonable restriction, where the state thinks that certain passages or the point of view of curfew, etc., needs to be done because of an emergency situation that has arisen in the country, and therefore it is the need of the hour for the government to govern the country or rule the country in that particular form. Now, on that note, let's come to Section 339, 340, 341, and 342 of the IPC. So the odd provisions, that is 339 and 341, it talks about wrongful restraint and punishment to wrongful restraint. And Section 340 and 342 talks about wrongful confinement and punishment to wrongful confinement. Now, interestingly enough, it has been put forth by many, the framers also, that wrongful restraint is more linear by nature and wrongful confinement is more circular by nature. I repeat, wrongful restraint is linear, kind of straight by nature, or in a particular tangential direction, but there's an element of 180 degrees appended to it. Wrongful confinement is more 360 by nature. There's this element of a periphery that is there. Why so? Why so? Because one, wrongful restraint is the genus, wrongful confinement is the species. If wrongful restraint, say for instance, is the universal set, then wrongful confinement will clearly be the subset. Why? Because in confinement also there is restraint. In restraint, of course, there is restraint because restraint is the mother law here. So if I am walking straight, somebody stops me, it is restraint. But right now I'm inside a room and there is a door this side. And maybe this door right at the rear, at the background, is the only option out of this particular room, and somebody locks the room. Of course, I've been stopped. Wrongful restraint has definitely happened. But will it just be a restraint? When I'm walking in this direction, somebody had stopped me, then maybe I'll take another direction. There's that east, west, north, maybe south has been blocked. So, other ways of maneuvering, of moving, or escaping or escape it is available. However, when I'm inside the four walls of a room or a public transport or a bus or a car or a tram or a taxi or what do you call that? Even for that matter, a train, and the doors are locked, it means it is circular by nature and not linear. Now, I'm not going to able to make a way for myself out of that territory. So if this room, like I mentioned, this door is locked from outside, now I don't have another exit option to go. Unlike wrongful restraint, one way restraint, I have two, three multiple other ways to move. Hence, keeping that into consideration, the case where the door is locked and I'm not able to move out of a particular place, it will come under the ambit of wrongful confinement. Now, clearly between the two, which is a more graver crime? It's a no-brainer, wrongful confinement, because it is way more dodgy and much more dangerous. Because I lack movement of any sorts here, because I'm bound within a stipulated territory. Unlike wrongful restraint, wherein I'm bound in one particular way or direction only, but I'm not bound within territory in a circular form or in a perpendicular, or like in whichever format it is. But yeah, it is not earmarked, or the yardstick is not there that you cannot move out of this Lakshman Rekha. Hence, this is the fundamental difference between the two. wrongful restraint on one hand and wrongful confinement on one hand, as is there in module 4 of your syllabus. Now, taking this discussion further, now I have a question. Question is that, to which probably I'm the one who will be giving the answer in a bit. Suppose there are two exit points in this particular room. One exit point right at the back, which is locked by the perpetrator, and there is another exit point right behind this camera through which I'm speaking, right behind it. Now, if that particular exit or door is open and I can move, then my case will be that of wrongful restraint because one movement was stopped, but there was a other passage of movement that was there, and therefore I could take that route out and move. But if that is also law, then to it is wrongful confinement. Both ends it's law. But my question is not that. It is the perpetrator who locks it. No, it's the perpetrator who stops me, or the alleged offender who is stopping me from going in a direction. And in my case, my very specific question in this regard is, what if the alleged offender puts a dog? This is the first proposition, okay? Puts a dog, a very dangerous form or species of dog. If I come out, the dog will bite me. Says that, if you come out of this side, then the dog will bite you. Will it come under wrongful confinement if that happens? And my second proposition to this entire question is, somebody from the outside says me that, you know what, the dog which is there outside, the dog which is there outside is a wild dog, it's a mad dog, and will bark and will bite you. And that person leaves, no problem. But he lied to me. Actually, outside there is no dog. He just gave a threat to me that if you go out, there is a dog which is kept which will bite you. But now, because that person has given me the threat, I have taken the threat seriously. Because this door is locked, that door I'm going to take, but the person has threatened me that if you try to go out from that particular door, then the dog will bite you. But there is no dog. He did not keep a dog, nothing. Then what happens? Can it be termed as wrongful confinement? Well, ponder over. The answer to that is yes. Why? Because the alleged offender has put a reasonable apprehension of fear in my mind, a trepidation, an alarm, which I believed, which I had reason to believe that the person what he is saying is correct. Reason to believe is section 26. Section 39 is voluntarily in my earlier video. Please pardon me. So it is voluntarily under section 39, and 26 is reason to believe. And therefore, that person voluntarily and deliberately mentioned that there is a dog because he wanted to create a fear and apprehension in my head that if I go out, I should think twice. And because of the fear factor that there is a mad dog outside, I might not leave the room, despite the fact there is no dog whatsoever. But on the other hand, it is equally true. I am very skeptical. I was very fearful that, what if the dog is actually there outside? Then I'm dead. Fact that the person toyed with my idea of understanding that, I will believe, and I believed him. It will be a case of wrongful confinement, irrespective of the fact whether the person is there outside or not there outside, because the alleged offender or the perpetrator has put me in a spot of bother by saying certain words which made me believe in good faith that yes, my life will be in danger if I take the other route to go out, and it will be a case of therefore wrongful confinement. As simple as that. On that note, I'll discuss a case with you. It's a very famous, a noted case, a precedent. The case is that of KPS Gill and Rupan Deol Bajaj. Now, KPS Gill is someone who is known. He was also associated with the Indian Hockey Federation, as an ISIFS officer, and from the Punjab cadre, etc. So, what happened is in Punjab, there was this huge, high profile meeting and after party of sorts, a get together, wherein Rupan Deol Bajaj, a very erudite, well spoken, and well qualified woman, a lady, had come, and all the top officials were present in that particular party. And the men were on one side forming a semicircle, and the women on the other side forming a semicircle. And of course, there were conversations, etc., happening like it happens in a normal party. Now, during the course of the party, what happened is people found that probably KPS Gill was behaving a little off the track when it came to sort of behavioral disposal with respect to some of the women in the party. And in the process, he went on to approach Mrs. Rupan Deol Bajaj as well for a conversation a couple of times. And she understood, she also felt uncomfortable. She was aware of things, etc. Now, the culmination of the incident that happens there is that the lady was sitting on a chair, and KPS Gill came and stood very close to the chair. So close, the proximity, the distance was so close, so narrow, that if she would have tried to get up, as per the facts of the case, that is, then it would lead to, like, collision of the two individuals, Mr. Gill standing and Miss Mrs. Bajaj standing up. So there'll be a collision. So, being a very smart and intelligent woman, what she did is she pulled back the chair just a little behind to create that space between the man standing and herself so that she can get up without any kind of obstruction. And she did that. She got up and she tried to maneuver past or move out, stating that she was not interested to talk, etc. Now, while this was being done, um, the lady was slapped on the lower posterior by the concerned individual. Um, of course, indecent behavior in a public place and yes, outraging the modesty of a woman under Section 354. Absolutely. Um, but in this context, why is it that I'm referring this case? Is because there is this element of wrongful restraint involved in this particular case. Although many would call it a case of offense against women, which is rightly so and very correctly so. There's no two ways about that. All said and done, the fact that when the concerned man had come and stood so close, so near to that woman, that the woman could not get up straight because she knew that, it would automatically touch the other person, like, it will automatically collide with the physical stature of the other person. So she had to back herself, the chair, in order to create a distance of non collision. And track past. Obviously, it is a clear case of wrongful restraint as well in this instant case. Very important. Because the person could not move in that particular direction. But there were other directions that were available. But say, for instance, had the lady been sitting with the chair connected to the wall, like here, and the man came and stood right next to the wall, close. Here is the wall here. Then that lady wouldn't have found any other space to, like, without touching, get up. So that is can could have been a slightly more dicey case or dicier case of wrongful confinement. But thankfully, here there was space for the other side. But the big moral of the story in this particular case and why I referred to this instant case was that, yes, although this was a case of unnecessary and an unfortunate advancement on the sexual autonomy or the modesty of a woman, also this was a case of con- wrongful restraint under Section 339, punishable under Section 341. Now, as I read the sections, you'll get a clear understanding. Whoever voluntarily, Section 39 is voluntarily, obstructs any person so as to prevent that person from proceeding in a direction in which that person has a right to proceed. Although there is a right to proceed, but that person has been obstructed illegally, unlawfully. Exception, the obstruction of a private way over land or water, which a person in good faith believes himself to be lawful right to obstruct, is not an offense within the meaning of the section. So therefore, A obstructs a path along Z has a right to pass. A not believing in good faith that he has a right to stop the path, Z thereby prevented from passing. A wrongfully restrains Z. So therefore, it is very clear the intention, the mala fide intent, the evil intent, the wrongful intent, the mens rea, the guilty mind, is to ensure that free passage is stopped illegally and, most importantly, unlawfully, in order to ensure that the person is hard done. Now, if you look into the punishment for wrongful restraint, it may extend up to 1 month or 500 rupees. And punishment for wrongful confinement, which may extend up to 1 month and 1000 rupees. And it clearly shows punishment when it comes to confinement goes up the ladder. Confinement is whoever wrongfully restrains any person in such a manner to prevent that person proceeding beyond a certain circumscribing limit. This is a very important phrase in the scheme of things. That's what we have been discussing at the very beginning. That one is linear by nature, another is circular by nature. Here it mentions in wrongful confinement, section 340, punishable under 342, as to prevent that person from proceeding beyond certain, look at the phrase here, not word but the phrase, circumscribing limits. Excuse me. And this circumscribing limit is the key to it. If it is a circumscribing limit, then you cannot go past and you've been stopped from going past. Hence, it will be a case of wrongful confinement. Now, I hope with this video you're understanding about two key facts or figures pertaining to wrongful restraint, wrongful confinement is more or less clear. And we shall continue in the next video of offense relating to body and reputation. And the next video, we shall start with the aspect of assault, force, and criminal force, and at the same time, criminal intimidation. And in the final video, we'll wrap it up with insult and defamation, which will be again very interesting, will be more focused towards the reputation part. So see you in the next video for assault force, criminal force, and maybe criminal intimidation as well. Thank you.